Professor Sundaraju, Mr. Shastri who just left, Mr. Ashokpati, Mr. Saravanan, Mr. Anand, and the distinguished honorable former judges of our High Court, Justice K.N. Basha, Justice R.S. Ramanathan, Justice Sudandram, and Justice Chandru, the stalwarts of our High Court, I should say. Usually we stand down and all the four judges are elevated, but it sometimes feels a little bit, I won't use the word uneasy, but absolutely a little bit uncomfortable, I should say, having the best of the judges sitting down and we standing up to give a topic on which they are right now pioneers so far as arbitration goes. But to the capacity of my realm to reach out some points which I thought I must share, I thought I will place my little bit of, I would say not just comments but observations so far as the Indian scenario is concerned, and will take a very short time to not touch upon some of the areas which my previous speaker, Professor Shastri had, I would say, touched, particularly in regard to his comments. I leave it to you to have your own judgment because he perfectly touched upon the Indian scenario a lot. In the past 2 decades, it has been seen that more and more parties, even Indian parties, have chosen to arbitrate outside India, especially in London and Singapore. Of late, there appears to be an increasing trend of people preferring arbitration in Hong Kong as well, thus leaving India behind in the global race to be an arbitration hub. The reasons for this can be manifold. One, the extensively intrusive approach taken by the courts in relation to arbitration in the previous decade in cases like the Bhatia International and Venture Global, which came to be overruled after a decade in 2012 in the Balco case. And second, the lack of infrastructure in the arbitration market in India in comparison to the setup in places like Singapore, Paris, London, etc., where the structural as well as the legal infrastructure are much between and much higher than the Indian scenario. To overcome the first of these 2 problems, the Parliament brought in the 2015 amendments, which have worked reasonably well, but for a certain glitches, which now the Parliament is seeking to amend by certain pending bills. It's the second of these criticisms that the need of institutional arbitration mostly is felt. The criticism of lack of infrastructure. When we say lack of infrastructure, it does not simply mean a big beautiful building, good lights, chairs, projectors, etc. They are important, but everything when we say as infrastructure, there are very specific advantages associated to the institutional setup itself, which one refers to. Internationally, it is accepted that institutional arbitrations should provide the following advantages, namely, firstly, predetermined arbitration procedure. All the popular institutions provide for arbitration procedure, and this saves parties and their lawyers the effort of determining the arbitration procedure. Some institutions also provide service of drafting an arbitration clause. This in turn prevents time-consuming litigation in court to determine aspects such as court seat, court appointment of arbitrator, and court interim reliefs, etc. The second, updated rules in lieu of the latest developments. This provides for updated rules taking into consideration the latest developments that are taking place in the arbitration practice. This ensures that the global best practices in the field of arbitration across the globe are adopted promptly and in a timely manner so as to achieve the goals of arbitration, that is, speedy and effective adjudication of disputes. Third, an efficient panel of arbitrator and professional support. This is one of the major benefits of institutional arbitration, international arbitration, institutions, etc., which usually benefit from vast databases of arbitrators in order to assist parties in appointing appropriate arbitrators for the resolution of their disputes. The institutions have panels of experienced arbitrators specializing in various areas like construction, maritime, contract, trade, commodities, etc., which are available to them. Fourth, well-built infrastructure. These institutions have a tremendous work ethic and provide latest infrastructural facilities. They have sophisticated conference halls. All the above mentioned advantages make the complete procedure speedy, risk-free, and efficient, and swiftly take the dispute resolution process towards better form. In addition to the above, I would like to add one big aspect which arbitral institutions in India must focus on. Several studies in the UK have shown that Singapore is growing as a preferred seat of arbitration for reasons beyond the perceived advantages which arbitral institutions anywhere must be able to provide. It is the availability of trained lawyers in the field of arbitration. It is now seen that there are an increasing number of specialist arbitration practitioners in places like Singapore who are specifically trained in the institution rules where they conduct arbitration and are also well versed with the globally preferred commercial law, that is the English common law. Training Indian practitioners in this front may be important to ensure that India is able to compete in the global market as an arbitration hub. It is important for the institutions to thus set up workshops and train Indian lawyers to deal with this need in the international market, to place India as a pioneering jurisdiction in the international arbitration market. Today, India is slowly moving towards a modern economy, and as per the OECD 2017 economic survey, India's growth was marked at 7.5%, which made India the fastest growing G20 economy. Its GDP is expanding rapidly. Since 2 decades, it has been a priority for policymakers to provide better investment opportunities and a hassle-free trade mechanism. At the same time, Indian lawmakers are focusing to provide better provisions of enforcing contracts and quick and easy means for resolution of disputes. India is progressing towards improving its global perception of doing business in India. According to the World Bank's rating on ease of doing business 2018, India ranked 100 out of 190 countries as compared to 131 in 2016. According to areas tracked by doing business in 2016-17, India was among the top 10 economies, improving the most in reforms reducing complexity, cost of the regulatory process in the area of starting a new business, getting credit facilities, and improving in the area of trading across borders. Even after prioritizing all the reforms, India still has a less effective legal system. It is a known fact that India has huge pendency of cases in various courts. As of 10/2/2018, there are more than 25 million cases pending. As a World Bank study, India is ranked as 164 on the ease of enforcing contracts and still takes 1,445 days to resolve a dispute. And the cost of dispute resolution is 31% of the claim value. The quality of the judicial process, which includes court structure and proceedings, case management, court automation, and alternate dispute resolution, is also poor. It is indexed at 10 out of 18. To conclude, it is this global perception that arbitration institutions have to overcome to set up India as an investment-friendly, arbitration-friendly global destination. With efforts such as the one being celebrated today, are a step in the right direction, and hope that day is not far when India rank high with flying colors in the global dispute resolution charts as well. Thank you very much.